Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to podcast number 156. First things first, I want to give a public thank you to Kunjan for his kind words about this podcast in the People Management magazine recently. Thank you very much indeed. Any feedback's appreciated, any public feedback, especially good public feedback, is doubly appreciated. We have, of course, 3 cases to discuss. The first deals with a claim by a man alleging he'd been unlawfully harassed by his female boss. The second looks at what happens when one party fails to enter a defence to a tribunal case. Does the tribunal simply go on to automatically award judgment, or is there a process to be gone through first? And finally, a case which got a bit of attention about whether vegetarianism is a protected belief for the purposes of the Equality Act 2010. Please don't forget, the usual way, the podcast is available via iTunes, Mayer Brown website, YouTube, Twitter feed, and we put out the links on the Twitter feed, of course, and Spotify, Google Play, Yahoo, etc., etc. So, first case, Raj and Capita Business Services Limited and Ms. Ward. So, this case concerns the definition of unlawful harassment and whether behaviour by the female manager, in this case, towards a male junior member of staff amounted to unlawful harassment. Now, the case has some useful pointers, and I should say also had the merit of generating more conversation at our recent training session amongst the employment team here than any other case recently. I'd be interested to know what people think. Background is that the claimant worked from autumn 2016 for Capita as a customer service agent. From May 2017, the second respondent, Ms. Ward, was his team leader. He didn't last long because in August 2017, his employment was terminated and there seemed to have been some concerns about his performance at work. He brought a series of tribunal claims, most of which failed, but I'm just going to focus on the unlawful sexual harassment case that he brought. And this arose because, he said, on various occasions when he was sitting at his desk, his manager, Ms. Ward, stood behind him and gave him a massage, feeling his shoulders, neck and back. Ms. Ward's explanation was that she'd tapped his shoulders, she'd only done it once, and that was all there was to it. Well, the definition of unlawful sexual harassment, Section 26 of the Equality Act 2010, and for our purposes, there are 2 ways of showing unlawful sexual harassment. First, a person, A, harasses another person. B, if A engages in unwanted conduct of a sexual nature, and the conduct has the purpose or effect of violating B's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment for B. Alternatively, it can be unlawful sexual harassment if A engages in unwanted conduct related to a relevant protected characteristic, in this case gender, and the conduct has the purpose or effect of violating B's dignity or creating the intimidating, hostile, etc. Or offensive environment for B. So you've got 2 forms of sexual harassment. There's harassment of a sexual nature, and there's unwanted conduct related to gender. Well, the employment tribunal, accepted that massages had taken place. They accepted physical contact had happened on 2 or 3 occasions. A number of the claimant's colleagues supported the claimant's account of matters. Indeed, the claimant had sought advice from a female colleague as to how he should dissuade his manager from doing this on further occasions. The tribunal started off by considering whether the harassment amounted to conduct of a sexual nature, i.e. the first form of harassment. And they didn't accept the contact was of that standard, and they drew a distinction between the claimant asserting that the manager had run her hands up and down the claimant's back, which would have been sexual, or a massage pure and simple, which they said was not conduct of a sexual nature. But that left the employment tribunal to determine whether or not an unwanted massage, which the tribunal accepted, had the effect of creating the intimidating, hostile, degrading, etc. environment. Was that unwanted conduct related to gender? The key question, they said, was whether the female manager giving a massage of 2 to 3 minutes long to a more junior male member of staff was conduct related to gender. The Employment Tribunal said no, it's not related to gender. They decided that the behaviour, the massage, was gender neutral. The contact was with a gender neutral part of the body in an open plan office. And the tribunal came to this conclusion partly on the basis that there were a number of other concerns raised by the claimant in other types of claim, which had been found to be unfounded. His performance difficulties, the need by the second manager, she said, to encourage the claimant's performance to improve, and the fact that, given that the tribunal had by this stage rejected allegations of race discrimination, this was, the tribunal said, indicative of a claimant who would see things that are not there. Claimant appealed to the Employment Appeal Tribunal, which was asked to consider 2 separate arguments. First, the claimant argued that since the tribunal had found that there had been unwanted conduct, and that had been found to have created the intimidating, hostile, degrading, humiliating or offensive environment, that should have been enough to shift the burden of proof, such that the respondents would have been forced to prove that there was no element of gender discrimination in the manager's behaviour, reversing the burden of proof. The AT did not accept this. There were 3 elements necessary for a sexual harassment claim, and the claimant had to prove facts in relation to all 3 of them, from which it could be concluded that harassment had occurred before the burden shifted to the respondent to prove that gender had in no sense played a part in what had occurred. Here, the EAT said it's not sufficient to prove sufficiently that 2 out of the 3 elements of the harassment test had occurred. That did not lead to an inference that the offensive conduct was related to gender. This is, of course, helpful for employers faced with a discrimination claim where unwise or foolish behaviour by a manager or a colleague may have occurred, and which the tribunal disapproves of, but is not obviously related to gender or race or any other protected characteristic. Secondly, the claimant, not unreasonably, argued that the tribunal had found that the manager's evidence as to what she had done had been disbelieved. In these circumstances, the claimant said there should be a greater willingness to find that the burden of proof had passed to the respondent. The EAT declined to take that step. They didn't think it was a necessary consequence of finding that the second manager's evidence on what she had done had been disbelieved, that the burden would shift. In any event, the tribunal, the Employment Tribunal, had decided the purpose of our massaging his shoulders was a misguided attempt at encouragement. In other words, even if the burden of proof had shifted, the EAT said this Employment Tribunal has found that the actual reason for what had happened was a non-discriminatory explanation for the conduct, i.e. misguided encouragement. As you can imagine, there was a range of views on this case in our training session, particularly with people taking views as to whether or not a male manager massaging the shoulders of a female employee would have been treated differently. It was, from the case, quite noticeable that this was the only occasion where the female manager had massaged anyone else's shoulders in the office. At the end of the day, the tribunal found there was a legitimate, albeit misguided, purpose for what happened, and therefore the outcome is an understandable one. I do tend to think, where I come out in all this, is that a tribunal might be more sceptical if a male manager was to do the same to a female employee. But the important point is that it's necessary to show that there is a gender element to what is happening in order for it to be unlawful sexual harassment, and assuming that the behaviour isn't of a sexual content by itself. So that's Raj and Capita Business Services Limited and Ward. Next up, Lemoyne and Sharma. This case looks at what happens where one party does not submit a defence to a claim by the other party. In this case, oddly, what happened was the claimant lodged a claim and was then countersued by her former employer, and she failed to lodge a defence to the counterclaim. But what the tribunal says here would apply equally where a claimant lodges a claim and the respondent doesn't put a defence in. So, just briefly on the facts, what happened was the claimant was employed to be a children's nanny during a trip to Thailand. She asserted she'd not been paid the money that she was due for working. The respondent entered defence to that claim, but counterclaimed, saying that she was looking to recover the money spent on the claimant's flight and accommodation. The claimant's claim was worth something like £670. The respondent's claim against the claimant was worth about £2,000. For whatever reason, the claimant did not lodge a defence to the respondent's claim, but both parties turned up to the full hearing, which was going to hear both claims. The claimant's claim against the respondent was dismissed at the full hearing, but the respondent's claim was upheld as a default judgment based on the fact no defence has been lodged. The claimant appealed against the tribunal's decision. So there were two separate points. The first appeal was against the tribunal's decision to grant a default judgment on the respondent's counterclaim. Secondly, it was said that the damages being claimed by the respondent did not flow legally from the alleged breach by the claimant, according to the respondent. The EAT took the opportunity to review what should happen where there is no timely defence lodged to a claim, and whether a tribunal can simply grant judgment on the claim without any consideration of the basis on which the claim is advanced by that party. The second point they consider is what should happen where there is a hearing in respect of an undefended claim and, as here, the other party, the one that has failed to lodge the defence, has turned up and wishes to be allowed to take part in the hearing. Rule 21 of the Employment Tribunal Rules and Procedures 2013 provides what happens when no defence has been received and there is no application for an extension of time or reconsideration. The Employment Tribunal should decide on the available material whether a determination can properly be made of the undefended claim. If it can properly be made, then the judge should issue judgment accordingly. Otherwise, a full hearing should be fixed. The party who has failed to lodge a defence is entitled to copies of the decisions coming out of the hearings, but can only participate in any hearing if and to the extent that party is permitted to do so by the tribunal. Pursuant to presidential guidance which has been issued and which is to be taken into account by tribunal as guidance, the tribunal, there is guidance related to Rule 21. This reiterates that the judge is to review the material in front of him or her and outlines the various orders that a judge in this situation, where there's been no defence lodged, the orders that the tribunal judge could make. Judgment will be issued if the judge is satisfied that the tribunal has sufficient information properly to do so. This could involve looking, according to the guidance, is the claim clearly stated? Are there any matters which might affect whether the tribunal has jurisdiction to hear the claim? The tribunal should also consider whether there are any burdens of proof that may be relevant. Any case management orders have been made. Has there been any response to those case management orders? If the employment judge has reasonable doubt as to the whole or any part of the undefended claim, then the claim should be listed for hearing, the guidance says. Here, the EAT emphasised it was necessary for the judge to decide whether on the proper material a determination of the claim, quote, can properly be made, unquote. If it cannot properly be made, a hearing had to be fixed. The EAT said that it envisaged in straightforward cases it could be possible to issue a judgment having gone through this process of consideration, and this might naturally occur most often in straightforward undefended money claims for wages, holiday pay, notice monies, that sort of stuff. However, the point was that the EAT was very clear about was that the rule did not require or indeed permit the judge to enter judgment simply because the claim was undefended, without going through the further consideration as to whether or not a determination of the claim could properly be made. The judge had to be satisfied on the information contained in the claim form and any other documents or materials before them, and, in view of the claim being undefended, that the factual element necessary to make a good claim in law are made out. This would involve treating what the party seeking the default judgment says in the form as undisputed fact, and then applying legal reasoning to it, legal tests to it. The judge also reminded tribunals that they should be considering the presidential guidance, even if it's not followed for some particular reason, and then explaining why not. Here, the EAT is very clear that the tribunal judgment had simply made a default judgment. There were no other reasons for making the judgment against the claimant other than that she'd failed to lodge a defence to the respondent's counterclaim. Here, the EAT also point out that the claimant was entitled to participate in her own claim. That had all gone through the normal process. That was still live at the point, and she wished to be allowed to participate in defending the counterclaim, which was also to be determined by the same tribunal. The claims overlapped to a significant extent. The judge should, according to the EAT, have considered whether the claimant should have been permitted to take part in the full hearing, given that the two claims overlapped, and that both parties were there and ready to go ahead. Therefore, if faced with a situation where the party you are litigating against has failed to lodge a defence in a tribunal claim, it may assist the tribunal to make an application for judgment to be entered, but drawing to the tribunal's attention the presidential guidance, the matters contained in it as to whether or not a judgment can be given. Conversely, if you have missed the deadline for a defence to claim, then making an application in relation to being allowed to participate in the ongoing claim pursuant to Rule 20 should be made as quickly as possible, setting out the reasons why the extension is needed, and potentially a draft of the response which that party wishes to lodge, albeit after the expiry of the deadline. So, that's the case of Lemoine and Sharma. Last case, Conisbee and Crossley Farms Limited. This is an employment tribunal decision. As such, it's not a binding precedent, but it is an interesting example of a tribunal grappling with whether an individual was entitled to protection for an alleged religious or philosophical breach. Background is the individual worked as a barman at a restaurant. There appears to be an argument at work which was something to do with an unironed shirt, and then the claimant asserted that he'd been sworn at by his manager publicly, and he then resigned. For reasons that are not entirely clear from the report, this then mutates into a claim that he was dismissed or treated adversely by reason of discrimination on the grounds of his religion or belief. What was the religion or belief in question, I hear you ask? It was vegetarianism. Sadly, the case does not make it clear how vegetarian links to the unironed shirt, but anyway, the tribunal had to consider whether vegetarianism in principle was capable of being a protected belief under the Equality Act 2010. Section 10 of the Equality Act 2010 provides that a religious belief means any religion, and a belief means, quote, any religious or philosophical belief, unquote. Courts have grappled on a number of occasions in other cases with whether a particular viewpoint amounted to a philosophical belief that was capable of being protected. Examples that have been upheld include a belief in climate change and a belief that mediums can speak to the dead. So where does vegetarianism fit in this? Well, Section 52 of the explanatory notes that come with the Equality Act 2010 fleshes out the test, if you excuse the terrible pun in the vegetarian circumstances, of what amounts to a belief capable of being protected. The belief must be genuinely held and not a mere opinion or viewpoint on the present state of information available. The belief must be a weighty and substantial aspect of human life and behaviour. The belief must attain a certain level of cogency, seriousness, cohesion and importance, and it must be worthy of respect in a democratic society, and the belief must be compatible with the human dignity and not conflict with the rights of others. The claimant pointed out the views put forward by the claimant were genuine. There was no suggestion it was made up or fanciful. He had a genuine belief that it is wrong and immoral to eat animals and subject them and the environment to cruelty. Meat farming accounts, allegedly, for a huge portion of the world's pollution, and it is clearly a significant aspect of human life and has a high level of cogency, he said. They also pointed out, the representatives for the claimant in this case, that in an earlier Supreme Court decision in a discussion on protected beliefs in connection with the European Convention on Human Rights, one of the judges in the Supreme Court had given pacifism and vegetarianism as quote-unquote uncontroversial examples of beliefs that were protected under the European Convention on Human Rights, and therefore should also, in the claimant's submissions, be protected here. Notwithstanding this, the tribunal decided that vegetarianism was not a protected belief. The respondent's argument was that it was not a belief, it was an opinion or viewpoint, and that it was knocked out on that ground. It was not a belief as to a substantial aspect of human life and behaviour, because it related to animals. It did not have a level of cogency, seriousness, cohesion, and importance necessary, and as thus, therefore, was not similar status or cogency to a religious belief. The tribunal accepted the claimant was a vegetarian. They accepted it as a genuine belief, but took the view that a belief in vegetarianism was merely an opinion and a viewpoint. As such, they felt it fell short of the necessary philosophical element to qualify for protection. They also seem to have taken the view, although it's a little bit unclear, but I have to say I think it's a bit bizarre, that vegetarianism is not a belief dealing with a substantial aspect of human life and behaviour. They seem to suggest that because it relates to animals' life and behaviour, it doesn't relate to human life and behaviour. The judgment's a bit unclear on this, but I have to say I do think that's a bit bizarre. They also refer to vegetarianism potentially being a lifestyle choice. There are many different reasons for vegetarians being vegetarians, the tribunal said. Lifestyle, health, diet, concern about the way animals are treated, personal taste, etc. And the tribunal contrasts this with veganism, which, according to the tribunal, is a coherent and cogent belief system. On that basis, they did not accept that vegetarianism amounted to a philosophical belief capable of protection under the Equality Act 2010, and the claimant lost. I think the case is, terrible pun here, hard to swallow. I'm far from convinced that all vegans are vegans for the same reason, and therefore the tribunal's distinction between veganism and vegetarianism seems, to me, to be forced. Secondly, I do understand that people who are vegetarians might be vegetarians for reasons that have nothing to do with a philosophical belief. If I'm a vegetarian simply because I don't like the taste of meat, that's not a philosophical belief. In the same way, I suppose, following the famous British Airways case of a number of years back, if I'm dismissed for wearing a cross, and I'm wearing a cross on my lapel because I'm a Christian, that is capable of being something connected with a religious belief. If I'm wearing a cross because I'm a devotee of Madonna, the singer, not the mother of Christ who appears in the Bible, then I'm not suffering religious discrimination if I'm dismissed for wearing a tribute to the pop singer. The tribunal does not appear to have asked here whether the belief of the individual in question was a philosophical belief for that person. They appear to have approached it as an abstract question and said that because some people would not have a philosophical belief leading them to practice vegetarianism, then vegetarianism was not a belief system per se. I have to say I'm not convinced of that. I also think it is suggested that if vegetarianism is excluded because it relates to animals rather than human, then that's clearly a very odd way of looking at things, not least because what humans eat is a substantial aspect of human life. Anyway, I'm not entirely sure why you couldn't approach this on the basis that you look at why this claimant was a vegetarian, and if it was a philosophical belief reason, then that's a philosophical belief. I think that something that could be a lifestyle or could be a philosophical belief doesn't cease to be capable of being a philosophical belief just because some people might hold it as a lifestyle choice. Anyway, as I said at the beginning of this, the tribunal decision is not a binding precedent on anyone else, but it is interesting. It possibly throws up some interesting questions about things that could be protected beliefs, but it may well depend on why the individual is espousing those beliefs, in my personal opinion. So that's Conisbee and Crossley Farms Limited. Thank you very much indeed for listening. I'm happy to announce that this podcast is now going to be prorogued for a short period to allow me to prepare the next podcast. In the meantime, hope everyone keeps safe. Please do let me know if you've got any questions, and see you on the other side of the Queen's speech. Thanks very much indeed.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.